SJC-13152, Carole, Ashe, and another, v. AMPM Safety LLC and others.
Okay, Attorney Kazarosian. Excuse me. Good morning, Chief Justice Budd and Associate Justices. May it please the Court. My name is Marcia Kazarosian. I represent the appellants who are the co-conservators of Thomas Ashe, the injured party in this matter. Your Honors, the main thrust of this appeal really boils down to whether or not a trial court has the discretion, or a trial court judge has the discretion to amend or change a rule of civil procedure when that's within the purview only of the Supreme Judicial Court, particularly when the word that's used therein doesn't have any ambiguity on its face.
I know you're going to get there, but let's cut to the chase. How do you distinguish the PIP case, Ortiz?
Well, I would distinguish that, Your Honor, for a number of reasons, but primarily in the PIP case, the court, in Ortiz, first of all, the court, using the rules of construction, determined that there was an ambiguity, the statutory construction, determined there was an ambiguity in the language in the PIP section of the no-fault statute. And it went to the no-fault statute and looked at the historic background of that statute and determined what the goals were. And the goals were...
I thought and this is helpful for me, so forgive me for interrupting you, but I thought what Justice Botsford wrote in Ortiz was that the word physician wasn't defined further, so it's going to look to see that.
Yes. And what they determined was in...
Just like in Rule 35.
Yes and no, Your Honor. I do agree. It's undefined in both places, but I would argue that the fact that it's undefined doesn't necessarily result in an ambiguity. Ortiz determined it did relative to the PIP section because the goal of PIP is to get fast, speedy payments to an injured person, regardless of fault, without litigation. It's a very separate and distinct thing. And one of the issues is you've got to have dentist bills that are being presented, you're going to have physical therapy bills that are being presented, and those bills need to be paid up to a maximum of $6,000 or $8,000, and they got to be done quickly, and there's no litigation involved, there's no fault involved. So what they determined was that if you maintained that strict plain and ordinary meaning of the word physician, it was going to contravene the goal of PIP and no fault. And in doing that, they properly, I would argue, expanded...
Although that wasn't in Ortiz, right? I mean, that's a thoughtful response, but we didn't say that in Ortiz, did we?
Well, the Ortiz court basically had looked at what the goals were and how it did contravene and why there was a reason for broadening that
So
rule.
what's the goal of Rule 35?
Rule 35, I would argue, is to manage and control physical and mental examinations of the parties.
But it's a truth-seeking function, correct?
It's a truth-seeking function, to be sure, but it has many conditions because physical and mental examinations are very intrusive. And so you have certain conditions under Rule 35 that you don't see normally. You know, you have to show a good cause for the examination. You have to show that the condition is in controversy, which we don't argue here. You have to have a time, place,
I'm sorry, can I ask you that? It is in controversy here.
Yes, we don't argue that it's not in controversy.
Okay.
Correct. So there are many...
But doesn't that answer the good cause?
They are two separate things, two separate analyses, good cause and in controversy. So the fact that it's in controversy doesn't necessarily mean there's good cause for the examination. For example, in this matter, we would argue, Your Honor, that because, number one, there were two Rule 35 mental examinations that were ordered that day, one from by Dr. Postal, who's a neuropsychologist and not a physician, also one by Dr. Dalton, who is a neurologist and a physician. They were both ordered of Mr. Ashe. We would also argue that prior to...
And who's retaining Dr. Dalton?
The appellee. So appellee has retained Dr. Dalton as their expert neurologist, okay, and appellee retained Dr. Postal as their expert neuropsychologist. And the reason that they retained Dr. Postal, as I read from their pleadings in their brief, is to review the documents that they received as a result of getting 79G medical records that provided the complete history of Mr. Ashe.
But let me ask you something. So you go to trial, and Dr. Dr. Dalton testifies, and he testifies to Mr. Shearer's work or the issue of mental deficits, and you, as a fabulous trial lawyer, say to him, well, you didn't do any paper and pencil tests, did you? And you start going into all the things that a neuropsychologist does. I mean, as you well know, there are psychiatrists and psychologists in the paper and pencil stuff. The deficits are usually done by psychologists. So I get your argument with Rule 35 and whether we have strict construction of the word physician. I'm not so enamored with your argument about good cause because of, as you probably recognize, the difference in those two disciplines, in particularly with psychologists studying the absence or presence of deficits.
Understood, Your Honor, and I would just offer this. When you have records of examinations, these examinations were done by Dr. Shear, who treated or examined Mr. Ashe back in 2017 and 2018, shortly after this incident occurred. And Dr. Shear provided all of the raw data to Dr. Postal, pursuant to a motion that was allowed, provided obviously all of the testing results, all of the examinations, and what Dr. Shear did at that time was give a snapshot of what Mr. Ashe's cognitive deficiencies were at that time. If the appellee wishes to have Dr. Postal also address what the cognitive issues were, there's nothing that stops Dr. Postal from reviewing the very same records that the appellants have. They have nothing more than we have. The only thing they don't have and that they seek
Is
now-
Dr. Shear, right? They want their own Dr. Shear.
They want their own Dr. Shear. I guess they do, yes, but Dr. Shear is not an expert.
They're tied to whatever tests that Dr. Shear gave. There might be other neurological, psychological tests that Dr. Postal wants to give, correct?
I can't deny that, Your Honor, but I would say that their argument is basically that they're not on the level playing field, that they don't have the same information the appellants have, and in fact, they do. They do have the same.
Well, can we just pick up on that, Mr. Kesrosian, about the level playing field? This issue of the application of Rule 35 and what a physician is interesting, but couldn't the judge, within the judge's discretion, look at the state of discovery and what the trial is going to be like and the fairness of the trial and say, as a matter of discovery, I think in analyzing the cognitive deficiencies here, that there should be an examination and it can be a neuropsychologist.
And are you saying
Separate and
not
distinct from
pursuant to
rule.
Rule 35?
Right.
I would argue that a trial court's discovery discretion does not extend to ordering physical or mental examinations of a party other than what they derive from Rule 35. Otherwise, we would have no Rule 35. And Schlagenhoff and the U.S. Supreme Court back in '64 really set the parameters for why we need a Rule 35 to protect against these kinds of abuses and to protect the patient from multiple exams, et cetera. That's why it's a very onerous rule. So I would argue, Your Honor, that there's broad discretion in a trial judge for discovery. There's no doubt about that. I wouldn't argue that.
And the states go both ways on this. I mean, some states have amended their statutes to conform with federal rule. Other states say, yeah, as this trial judge said, was close enough. Well, that's what she said.
Yes.
But other states take your position, correct?
Most states, I think there's only 5 states who have not amended their rule, and tellingly, they've amended their rule. Prior to amending their rule, they were nearly uniformly consistent in not expanding the word physician.
And that's why they amended.
And then they amended the rule. And, Your Honor, I'd point out, we have had this rule despite the fact that the federal court has amended the rule twice, once in '88, once in '91. We have not amended the rule. And I would suggest that the way to amend a rule is to go through the rule process of the Advisory Committee on the Rules of Civil Procedure presents a proposal. It's sent out for invitation for comment to all the stakeholders in the Commonwealth, and you get contemplative input that's very important when you deal with language in a rule. So, for example, and I think one of the courts, it did go to the High Court, I think, in South Carolina. That was the one place it went to a high court before the rule was amended. And it was very important that they the concern they had was, you're gonna have too many different possibilities with a trial court judge. Where do we end it? Which disciplines? Is it gonna be physical therapists? What kind of certifications? What kind of licensures? And that's gonna cause more problems every time this case comes up if it's decided on a one case, one specific issue, rather than a contemplative process in addressing particular language and what the best way to structure it is, if it's going to be amended. Maybe it should, I don't know, that's above my pay grade, but I would argue that that's something within the purview of this court to do in the process of amending a rule rather than on a case-by-case basis. It's not gonna help litigation, it's gonna make things worse. The other, I would just, on good cause, if I could, because I think I have a couple of points that I'd like to just add to. The other issue, I think, in determining good cause is that a judge is also supposed to take into consideration the age and condition of the person. I don't think there's any dispute that Mr. Ashe has a condition. He's very, he's compromised mentally and physically. And to put him through 2 mental examinations without any showing, and there was no discussion, there was no questioning by the trial court judge, nothing that went to the point of what good cause would be, other than to determine that it was a matter in controversy. So we would,
I read the brief hearing, and I don't remember, maybe it was in the papers, that argument being made about the detrimental effects on Mr. Ashe. Was that raised below?
no, as far as I was, we just generally said that we did not agree that there was good cause for the
Right, because I don't,
examination.
yeah,
Yes,
that
correct.
part you're talking, I don't remember that.
I wouldn't argue with you on that.
Okay.
I would just close in saying basically that to protect patients from multiple exams and from abuse, and to promote the goal of generally the rules of civil procedure, putting aside the goal of Rule 35, it's to keep and maintain speedy and efficient and just determination of cases. If this matter, for example, on the definition of the word physician, were to be changed here in this particular case on these facts, I would submit that that's going to open up a great door of more litigation, more interpretation, a lot more argument about what every nuance of the word means. This has been used in its plain and normal definition of the word, and even the trial court judge, when she made her decision, she specifically said, a neuropsychologist is close enough to a medical physician, to me, to come within the ambit of the rule. There was no ambiguity in her understanding of what that word meant, and there was no confusion in her mind. It was just, it didn't fit the request that she had that she felt should happen, and that's not respectfully the way the court should
Well, I don't know which way this case is going to come out, but I can probably guess that either way, it's going to result in a referral to the Rules Committee, as you suggest.
And I think that's the most appropriate way, because if you don't, then, or if it doesn't happen that way, so many of the stakeholders will be disenfranchised as to their very important input when you're talking about wordsmithing a rule, or what language to use, or what disciplines to include, and that includes research done about other jurisdictions, et cetera. So far, we haven't done it, and I think there's a reason why we haven't.
Can I ask you about your notice requirement argument? Doesn't that go to the order?
When, I'm not sure I understand what you mean.
That is, under Rule 35, it says the order shall specify the time, place, manner, condition, and scope of the examination.
Yes, it does go to the order, Your
Okay,
Honor.
so that's something that the judge does.
It is with, yes,
It's a
that's up to the
requirement-
judge.
It's not a requirement of the person seeking the examination under Rule 35.
No, well, they would present that to, if they were seeking the examination, they would be proposing that to the judge. It would be in the order. I don't think an order can come down without that information. But yes, that is in the order.
Okay.
So is that a problem here?
What we had argued as an issue with the order was that it came down, that there was an abuse of discretion because it came down so long after the discovery deadline had ended, and so long after we had provided multiple extensions of the deadline to appellee, and then it's, even after that, it came down. So that's basically what our argument is there. I think the discovery deadline was January 2nd of 2018. It was extended a couple of times till the middle of December 2019, and this did not occur until 2020.
All right, thank you.
Thank you, Your Honor.
Attorney Lavoy.
May it please the court, Your Honors, Chief Justice Budd, Mark Lavoy, on behalf of, from McDonough Hacking, Lavoy, and Salem, on behalf of the defendant, Shawmut Woodworking and Supply. The court has already recognized that this is actually a great opportunity for the court to look at Rule 35, and as Justice Lowy references, to affirm the trial court's broad discretion over the scope and conduct of discovery.
Let me ask you, so we have a federal rule that changed, and we have a bunch of states respond to that and change their rule. We look at the federal rules all the time, and we didn't change our rule. Doesn't physician mean physician?
Your Honor, my understanding of the court's earlier rulings, Polednik versus Rent Control of Brookline, 397 Mass. 854, the absence of an amendment cannot be interpreted to require a narrow definition of a statute. And what the word physician has been interpreted before the federal rules were first amended in Massey, a Pennsylvania case, that it would include healthcare providers such as a neuropsychologist. That was in 1983. So there's pre-existing case law supporting the federal rule, including the definition of physician. If the court needs to look further, as you have correctly pointed out in Gaziano, in your Justice Gaziano, I'm getting ahead of myself. In Ortiz, the PIP statute case, this court looked at the definition of physician and determined that the dictionary definition, one who's skilled in the healing arts, applied, and it looked at 3 different definitions, all of which encompass that concept.
But we, as counsel pointed out, the PIP context is a bit different than litigation, correct? It's no fault, and we're trying to...
No question.
You know, we're trying to give people that are injured money quickly and so they can get on with their lives, correct?
No question, Your Honor. But I guess what I'm saying is your point is that what does the word physician mean? And in its ordinary context, this court in 2015 said...
Well, I think just what Justice Botsford wrote in Ortiz was that we were going to interpret it consonant with the statutory purpose. So we have to look at the purpose of either the rule or the statute. And that's why I'm questioning, what is the purpose of Rule 35? Does it allow for physician to not just be physicians, essentially?
Your Honor, I would suggest yes, and I would, it's really the interplay of Rule 35 and 23379G, which is at issue here. 23379G covers what evidence is going into court from medical providers, and it uses the word physician and dentists. And in that, physicians and dentists shall include, of the number of things, and we cite this in our brief, psychologists. So that allows the plaintiffs to take a neuropsychological report and put it into evidence without ever having to call that neuropsychologist. It leaves the defendant with the trouble of having to decide, do we call this neuropsychologist in and cross-examine them and then wait for the bomb to hit when they get direct exam to put in their opinions? Or does the defendant then try, alternatively, to get its own evidence through its own neuropsychologist to perform testing? And that's precisely what we tried to do here.
Or, as was pointed out, you have Dr. Postal look at the records of Scheer and give an opinion based upon those pen and paper tests.
Certainly, Your Honor, and I've done that before. I've had Dr. Postal come in and testify in brain injury cases and done precisely that, because the court in Coyman, I was the defendant in that case moving for that motion. The court didn't allow it. And so I took my medicine and had Dr. Postal come in. But that doesn't mean it's fair. And what we're talking about here is fairness. So after Koyman, I said, enough of the Rule 35 idea. Let's do this, as Judge Agnes suggested in 2004, let's talk about the scope of discovery, Rule 1, what is a just, fair determination at trial, and let's ask for the court's discretion.
So you both cite a number of trial court decisions. What, if you could distill it for me, what's the breakdown about the number of times you've won on this issue and lost on this
Sure.
issue?
The breakdown is there are 15 cases cited about Rule 35. 5 the plaintiffs cite on vocational rehabilitation counselors, all 5, stemming from the appeals court case, I'm blanking on the name, Melody, which we cited in our brief. I had one of those 5 cases back in 2007 because I feel that this is an inherently unfair issue where we don't get the same access to certain experts. So that's those 5 cases. Then there are 11 other cases, including this one, that are either pending or decided, some of which are still pending. I have the Garrity case, which is one which we worked it out with Judge Canone. And the most recent case we supplemented with was Judge Wilson, the Kelly case, excuse me. And the rationale is 6-5, as I see it. So it's close. But if I could get back to the concept of 233 and the interplay, 239G and the interplay with Rule 35, because we see this as defendants in many cases. Whenever there's a brain injury case, the report goes in, but the neuropsychologist doesn't necessarily testify. So we can't cross-examine them live unless we take that Hobson's choice. So instead, we have hire a neuropsych to examine them. What we can't do, though, is offer affirmative evidence, which would be, as you pointed out, Justice Gaziano, different tests. So perfect example is this case. Mr. Ashe had a terrible fall, 40 feet, fractures all the bones in his face, also sustains a brain injury, a serious brain injury, from which he largely recovers, we believe. Dr. Scheer does not hold that view. He believes that Mr. Ashe had cognitive deficits, attention, memory, executive function. And he performed certain tests to establish that. Those tests include tests on attention and executive function, which require visual acuity. As part of Mr. Ashe's injuries, he sustained blindness in one eye, his optic nerve was severed, and he sustained ptosis in the other eye, which means his lid is down over his pupil, basically. So he has an extraordinarily hard time reading images. And one of the tests, of the battery of tests for visual imagery, requires that the Connors Continuous Performance Test, speaking with my neuropsychologist. And that test requires quick decisions on visual cues which come up on the screen. It's a computer screen. In that test, he bombed it. 1 percentile, the lowest you could get. And I asked this neuropsychologist, well, what would you do? And her answer is, you can do it auditory, meaning by hearing, where the eyes don't come into play. And this is what neuropsychologists do. They look at the cohort. How do we make this person closest to the cohort so we can ultimately evaluate where the deficit is? And so what happened here is Dr. Scheer has taken a number of visual tests and turned them into a deficit when the deficit doesn't per se exist. Mr. Ashe shows his verbal IQ and his other IQ, his IQ testing, I should say, shows that he's normal in many functions, but he's not normal in all functions because he's has this visual problem and he doesn't test well. So it brings all the scores down, skews the results, and we're not able to put in affirmative evidence to refute that.
So I understand your position with 79G, because 79G provides an opportunity for a report to come in as to diagnosis and treatment without the medical provider coming in. However, it's interesting, you're referencing that rule, that statute that passed to make it easier to try cases without having experts or providers come in as a rationale to have an expert come in.
Sure, because, Your Honor, what happens here, and I hasten, I'm going to use some imagery here. A sword, a shield, and a bootstrap. The sword is 23379G, get the evidence in. That's what the plaintiffs do. The shield is Rule 35. You can't get that neuropsychologist in because she's not a physician. The bootstrap, and this is a key point, is the next expert who comes in, and in this case it's Nurse Adele for the plaintiffs, who will testify as a life care planner, Nurse Pollard, Adele Pollard. As a life care planner, she'll testify that the deficits found by Dr. Scheer, which we challenge, result in a need for permanent care in a life care facility to the tune, a nursing facility, to the tune of $3 million.
Counsel, I have one question that may not be particularly apt, but could a neuropsychiatrist do the same test?
A neuropsychiatrist is in essence, by my understanding, Your Honor, a psychiatrist
Right.
who works, with certain aspects of the brain, apparently. They do certain tests, right? They do some tests, but they don't typically do the battery of tests and
They
the
are
analysis.
physicians, and they are MDs.
They are
So I
physicians,
was
and-
just wondering if you,
Well, actually, it brings a good point, Your Honor. What I'm hearing from the defendant, the plaintiff, is that they object to our Dr. Postal doing the testing because she's not a physician. So does that mean this court could order us to say, okay, defendant, you can go get a neuropsychiatrist to do the testing, then give it to Dr. Postal and she can interpret it? I mean, in essence, that's what they're saying. Because, that's the argument I read in the brief, which is get a doctor to do it, which was one of the Superior Court justices' findings. That's the remedy. Well, in fairness, that's not really the remedy. What we'd like to do is have the same opportunity that the plaintiffs had to have their client, tested. And so we're not asking for anything more than they've asked, than they've gotten. And the other thing is, we spent all this time talking about Rule 35, but Justice Lowy correctly pointed out, when I made this motion, it wasn't under Rule 35, it was to the sound discretion of the trial court.
But why isn't Ms. Kazarojian correct that if the judge, within his or her broad discovery discretion, can just order this, why do you need Rule 35? What's Rule 35 there for?
You mean why is the rule there at all?
That was the
Well,
argument.
Your
There's
Honor,
no
that's,
limitation.
yeah, that's true of other issues too, though. We could take that same argument and use it with expert witnesses. Federal court says you can take an expert witness by choice. Superior Court, the rule doesn't allow for expert witness depositions. The judge has to be the gatekeeper. So this happens in rules. There are certain things outside the rule which, as many of you know, having been trial court judges, you need to make decisions on. It's ultimately, the goal is to have fairness.
I understand, but what the plaintiff would argue is, good point, except for if the rule said there were no expert depositions, could the judge say, nonetheless, separate from the rule that there's no expert depositions, I'm going to order a deposition here within my discretion. That's their point.
Well, yeah, their point says that, but the rule doesn't say only medical doctors. The rule says physicians. And the history of this court and of the legislature is physicians is more than a medical doctor. right?
Is
So-
it going to include OTs and PTs and the litany of?
Oh, the slippery slope? Well, you know, fortunately, that's your pay grade, not mine, but what I would say, Your Honor, is the federal court has said psychologists and other licensed or certified individuals, appropriate license, actually, I'll give you the exact, clinical psychologists and other certified or licensed professionals. So hypothetically, I'm running out of time, I apologize. But in the end, I'd ask that the court consider this issue, which is really about fairness, and affirm the trial court's broad discretion to order this examination. Actually, it's a psychological testing and interview, neuropsychological testing and interview. And I'll rest on my brief. Thank you very much.
Thank you.